Christian Phillip.
Natalie Zund on behalf of the people.
Good afternoon, Your Honor. Rita White on behalf of, please state your name for the record, Mr. Phillip.
Christian Jeremiah Philip.
This is your motion. You may go ahead.
Yes, Your Honor. I did submit and file a motion with to the court, and I did provide notice to the prosecutor's office back in late August. Your Honor, I filed a motion requesting withdrawal of Mr. Phillip's plea. I did initially speak with an attorney on the morning of the plea, and I was advised that the nature of the charges that Mr. Phillip was offered in terms of pleading guilty to one count of domestic violence under 769.4A, and then a reduction to attempt R&O of a police officer resisting obstructing, which reduced it down to a misdemeanor with a dismissal of the remaining charges with potential diversion on the R&O, and again, under advisement on the domestic violence charge would be okay. However, would not provide any consequences to his immigration status because Mr. Phillip is currently a green card holder. He does have permanent residence, but he is not a full citizen of the United States. So after speaking and go further, my own independent immigration attorney profession self, I did some further research into potential possible issues that may arise given the fact that this domestic violence charge does carry a level of moral turpitude. So I did consult with an experienced immigration attorney that now I see was much more experienced than the previous attorney that I spoke with, and realized that I provided misinformation to Mr. Phillip in terms of his immigration consequences. And given the fact that this attorney that I spoke to provided a very detailed 6-page letter with case law statutes that really connect to Mr. Phillip's potential consequences, which will lead to a high level of deportation if he does plead and accept the offer that he was provided. I did advise Mr. Phillip of his consequences, as he did also was advised by the immigration attorney that he met with for at least over several hours. They went through in detail all of the factors regarding this case and his background, etc. So based on the fact that either way, I do not want my client put in a position where he would be deported, given the fact that his wife is with him, who is the complainant. They have young children. They've lived in the United States for many years. They both are working, and I don't want to break up the family or cause any distress. So I would really like to proceed with renegotiating this matter further. So with that, based on my client not knowingly, voluntarily entering into the plea, given his misinformation of his immigration consequences, I'm asking that you grant my request to withdraw his plea.
How does that relate to knowing? I mean, he knew what he was pleading to.
Correct.
I mean, nothing in what the plea was affected the voluntariness of the plea.
Yes, Your
Right?
Honor, it did affect the voluntariness of the plea because had he been advised of the actual nature and potential consequences of his immigration status, he would not have entered into the plea, nor would I have advised him to enter into the plea.
Response from the people.
Your Honor, the people believe at the time the plea was entered that it was knowing and voluntary, as the defendant did have a chance to talk to an immigration attorney. However, we would leave this in the discretion of the court.
When I read the motion, I don't want anybody necessarily breaking privilege, but I have the representations of counsel regarding this, but I don't have any of the documentation that you're claiming causes the plea to be set aside. And what gives the court some hesitation in that regard is this was never this case wasn't about his immigration status as we were going through everything prior to the plea and anything being taken. This was about potentially mental health concerns, other things that might have been going on, but it was not certainly about that issue. It then gets before Judge Freshour for the entry of for sentencing, and then it becomes about this issue. So while the issue on the face of it might be one that the court should be concerned about, I have nothing to say that you talk about a 6-page letter. I don't have that letter. I don't have anything on the one hand that says he received certain advice the first time with the plea, and then received advice in a different direction afterwards. So where is that information?
Your Honor, just to give you a little bit of timeline, after my client took the plea, prior to the sentencing, I did submit a lengthy deviation letter to the prosecutor's office, given the fact that it flagged my current concern with his immigration consequences. So what happened then is I received a response from the prosecutor's office indicating they too would like to meet to look into a second opinion from an immigration attorney to provide further background in terms of Mr. Phillips' possible immigration consequences. I did indeed do that, and I did provide a copy to APA Kirby, also the prosecutor that oversees the entire office, and some other accompanying assistant prosecutors. And that's when I did receive a response that either we proceed with withdrawal of the plea or we proceed with this sentencing. However, this is a privileged letter that I would prefer that if it's going to be sent with you, sent to you, it stays with you. But I would have no issue in terms of recalling this case, putting it over for you to review this letter that would provide this court very learned information regarding immigration consequences when it comes to criminal matters. So I can provide.
But no, it's not. That's not the issue, Ms. White. The issue is the claim here is that at the time of the plea, he was advised of one thing. Then subsequently, he's advised of something else. I have neither before me with this motion to withdraw the plea.
Yes,
and
Your Honor.
it wasn't something, at least from the court's perspective and the court's recollection of the case, that was even at issue in the prior proceedings.
Yes, Your Honor. With regards
before
to
me.
Yes, with regards to advice to a client, as we know, attorney-client privilege stands, and I am not going to place a record of a transcript of my conversation with Mr. Phillip advising him of what his immigration consequences were or are. What this is this was an off-the-record conversation that I had with Mr. Phillip with an immigration attorney on the date of sentencing. And that's when, Your Honor, as you went through his constitutional rights, I do recall, we can pull the transcript, but I'm certain and confident that you did speak with Mr. Phillip on the record and asked him, is he aware of his immigration consequences regarding taking this plea? Mr. Phillip answered in the positive. Yes, he was. But however, this is not about Mr. Phillips. If this case is pursuant to Padilla v. Kentucky, is about ineffective assistance. This is my issue. I misadvised Mr. Phillip of his immigration consequences from receiving misinformation from a different attorney.
Well, that then gets to a whole other issue of potentially having, and I was trying to avoid it, but if that's how you view the issue, then I've got to have a hearing.
That's fine.
I mean, I have to have an evidentiary hearing. I mean, I'm trying to avoid it because you're telling me there's one thing that happened, there's this. You want to cloak that in attorney-client privilege. I get that, but I can't. I mean, otherwise, what ends up happening is every plea I take would be subject to being set aside on some grounds that the court can't even see. You're telling me there's a 6-page letter. Okay, that's out there. You're telling me that there's other advice previous. Again, I don't have either one of them. And then when I tell you I don't have either one, you say, well, it's not on the defendant, who I guess would have used that advice. That is all of a sudden on you, and that ineffective assistance of counsel which if that's the case, then I've got a whole other issue for me to deal with. So you want me to set this for an evidentiary hearing against her? I mean, I'm not sure what you want me to do to try to get to the point where I could even begin to grant your relief.
Well, in terms of a Ginther hearing, the purpose of a Ginther hearing is to determine and find that an attorney was ineffective. I've been in practice for 23 years plus years, and I don't do this normally, but I will acknowledge that I was ineffective. And pursuant to Padilla v. Kentucky 559 U.S. 3656.
I know Padilla very well, counsel.
So I'm acknowledging I was ineffective, and he was misadvised of his immigration consequences.
But
And that would
counsel,
call for.
Can't do it that way. Because the problem would be that every plea that we take that somebody may not like, either the sentence or anything else, somebody would come forth and say, I'm ineffective, I didn't tell my client this, or I told them something, and I don't have a hearing to say whether or not that would have any impact.
I have no issue or problem with holding a Ginther hearing. I'm fine with that, in which Mr. Phillip would be prepared to testify also.
Well, okay. I don't have a problem setting that. But you understand that it can't be just your admission that you were ineffective.
Correct.
I mean, because somebody's going to have to back up that certain advice was given, potentially relied upon, shouldn't have been, and then there is this other evidence that was relied upon. I mean, it's going to come down to the same thing. But it doesn't matter to me how we do it, per se, but that's what's going to have to end up happening. How long will it take you to prepare for a Ginther?
Couple weeks, 2 weeks.
Do we have? It's gonna have to be in person because I got. I'll set the Ginther hearing for Tuesday, October 3rd. That's in person. Before me, 9 a.m.
Your Honor, is 10 o'clock? Okay.
Pardon?
Will 10 o'clock work? I have a matter in Detroit at 9 a.m.
Fine, we'll set it at 10.
Thank you, Your Honor.